Hi class, welcome to Chapter 6, Lecture on Confidentiality, Ethical and Legal Issues. We'll be looking at about 7 different topics here in this chapter. The first thing you'll look at is confidentiality related to or related terms such as privileged communication, privacy. You'll also be looking at how do we balance disclosure as a professional counselor and protecting victims. We'll also be looking at what are the legal precedents that can guide you and help you discern when it's appropriate to make a disclosure. We'll be looking at fourth, mitigating risks. So how can you reduce or manage your risk to avoid liability if possible? Assessing suicidal behavior. We'll look at vulnerable populations. And finally, disclosures related to HIV. So you'll find in your chapter that your book talks about confidentiality, and basically you'll note that even when you begin counseling, confidentiality is really a very important part of not only developing rapport, but keeping rapport, and it's the center point for an effective relationship, right? So if your client doesn't feel that they can trust you to maintain certain things that they talk to you about, then the relationship can be impacted. And it's also your ethical duty to protect confidentiality, okay? So it's an ethical duty to protect confidentiality. Now, some related terms are privileged communication and privacy. And you'll see on the slide here that privileged communication is really a legal concept. And think about it, you've heard that term before when you hear doctor-patient relationship or attorney-client privilege. So that varies from state to state. I want you all to take a look at what does Alabama say about privileged communication. Finally, we have privacy. It is your constitutional right to be left alone and to control your personal information. So as you think about our quizzes and projects and your ethical practice, think about the differences between confidentiality, privileged communication, and privacy. And I want you to think about and examine what those things are in relation to Alabama law. Now, protecting clients' rights, that is your ethical job. So in order to do that, there's an ethical model that tells you how to go about that according to your author. And so I want you to take a closer look at those steps. There are about 8 of them. Well, 6, I'm sorry. And I want you to take a look. So what that means is if you need to violate or you need to disclose, not violate, but disclose someone's confidential information, there should be a series of steps that you go through that you ask yourself before you do that. And this is what this model is talking about. Now, of course, you're familiar with the limits of confidentiality, but there are a couple that you probably haven't thought about. So remember, confidentiality, refer back to that very first slide of what it is. These disclosures can be made, a person's confidential information, in other words, there are limits. You cannot promise your client that everything that they say to you will remain confidential. There are some limits, and you'll recall from our last chapter when talking about informed consents that you have to discuss with the client. So of course this includes if the client planned to hurt themselves or they have an intent to break the law. There are also limits to confidentiality when the counselor is being supervised. So if you're an ALC, remember I told you before that, for example, I would have to have access to every client file, every client information, because potentially if there's an issue, then you might have to discuss that with me. So that's a limit of confidentiality. Now, there's also, if there is a court order that requires the counselor to make certain records available. So you can't promise unendingly to keep everything your client says confidential. Now, also, we talked a little bit about privacy issues regarding telecommunications devices. Again, won't go through all of these, but keep in mind if you were leaving a message on your client's phone, how do you know who your client or who's going to retrieve those messages? You want to be mindful of doing things like playing messages on speakerphone. All of those can impact your client's privacy and confidentiality. So read through all of those so that you'll be able to understand what's going on there. Now, want you to be professional and cautious when you're talking about confidential information over the telephone. There will be times that you'll have to talk about what's going on with your client. So you want to, if you're in the car using Bluetooth and someone's there, you want to be mindful of those sorts of things. Who could possibly hear your conversation? You want to talk to your client if they're talking to you and they're not in a private place. So always be mindful of what you say on the phone to the client, because you never know when that could be intercepted. Now, there are laws in place to protect the gaps in confidential information, and one of those laws that's in place is HIPAA, H-I-P-A-A, which stands for the Health Insurance Portability and Accountability Act. And so basically, HIPAA is a law with a set of 4 standards that guide how you communicate or handle or transmit health information. So you've probably heard about HIPAA, but this is just a little bit more detail about it. Now, there are 4 standards in HIPAA, and they are privacy requirements, electronic transmission, security requirements, and national identifier requirements. So you'll read about those in your textbook. But anyone who transmits any kind of electronic information are required to follow HIPAA guidelines. So if you send a fax, then you have to use or you have to be HIPAA compliant. So you'll notice that almost every doctor's office, if you're a billing company or your office uses an outside billing company, then you would have to be compliant with HIPAA practices and policies. Now, how do we protect potential victims? Well, remember, when you have your client, your responsibility is to your client, but there's also responsibility that you have to protect potential victims. And so this is where we talk about this delicate balance that comes in place. Now, it's your job to exercise skill and care to identify, protect, and treat those clients who could be dangerous. Okay, if not, you could face liability for civil damages. So even though you might not be criminally responsible, you could in fact be civilly responsible, meaning someone could sue you for your private, the finances, your business, that sort of thing. So the responsibility is upon you to, if you fail to diagnose or to predict dangerousness. Now, don't be overwhelmed with this here. You just have a responsibility to do your best, okay? So I'm going to leave you with that. Now, I want you to pay very, very, very close attention to these legal precedents, because you probably say, well, how do I know when I can disclose? How do I know at what point I need to break my client's confidentiality to protect victims? Well, you have a duty to warn and to protect, and that comes from the Tarasoff case. And if you're not familiar with that case, please read that. That involved a young man who was visiting a psychologist, and the psychologist attempted to warn the victim. He warned the police. So you have a duty to warn if someone intends to harm themselves or someone else, and you have the duty to protect the victim. Now, the Bradley case is a duty not to negligently release a dangerous client, and the Jablonski case deals with duty to commit a dangerous individual. So you need to know each one of those cases very, very closely. And there are some other cases here that talk, like the Jaffe case and the Headland case, that are very important as well. Now, how do you reduce your liability in these cases? Because we see a lot of these cases come up where people say, well, you violated my confidentiality. If you really strongly felt like someone was at risk of being harmed, well, before you do that, these are what we call risk management guidelines, right? So you want to consult with an attorney if you're not clear about your legal duty. And also consult with your colleagues or a supervisor, but you've got to know the relevant laws in your state. So in Alabama, before you were to break, unless it was imminent danger, if you've got a minute to call and check with an attorney, do that. Remember, we talked about the American Counseling Association. If not, then you consult with a colleague. You also want to always inquire about the client's access to weapons, homicidal ideation, all those sorts of things. consider all the steps and your consequences, okay? And I'll let you all go through the rest of those, but you always, like I said last class, need to document the actions that you take. Now, we see that school suicides or teen suicide is on the rise. So what this means that if you're a school counselor, you have to be educated about what's going on and the risk factors for adolescent suicide, because school counselors aren't always licensed, okay? Now, they need to be trained in understanding about student suicide. They need to be able to make assessment. And one of the first cases that addressed school counselor liability for student suicide was Easel versus Board of Education. So pay attention to that. School counselors do have they can be liable for certain behaviors. So again, the guidelines for assessing suicidal behavior: number one, take direct verbal warnings very seriously. Pay attention to previous suicide attempts and identify those clients suffering from depression. We know that there is a direct link between depression and suicide. Be alert to feelings of hopelessness. So if you have clients who can't think about their future, who refuse to see a future, that kind of language should clue you in about hopelessness. Explore interpersonal stressors, and I'll let you read the rest of those. Now, it is your job to protect children, elderly, and dependent adults from harm, okay? So again, these are what we call vulnerable populations. You all are mandatory reporters. And what that is that's designed for you to be able to have an avenue to report suspected cases of child abuse, elder abuse, or dependent adult abuse. So what we mean here, if you have people that have an intellectual disability, or young children, or the elderly who may have dementia, it is your responsibility to report cases of suspected cases of those abuse of those populations. If any of those populations disclose to you that they are being abused, you are to immediately report. If not, you may suffer from penalty of a fine or imprisonment. So you have an obligation to protect those who cannot advocate for themselves. And again, you can see some types of elder abuse here. And when we say elder, we mean those older adults, aging populations here. So physical abuse, sexual abuse, any of those, abandonment, financial or material exploitation, any of those require you to make the report. And you would make the report to the Department of Human Resources or to legal authorities. Now, disclosure of HIV status, that is a new one. It's a health issue, but the law is not very clear pertaining to the duty to protect in cases pertaining to HIV status. Now, I have seen cases where if the person actually had full-blown AIDS and they were having unprotected sex, I have seen where those people have been reported and charged with attempted murder. So you'll have to check Alabama and see what does Alabama say about disclosing. Now, there's a difference between HIV and AIDS, okay? So how to handle that from a legal perspective, you have to be very careful about breaching someone's confidentiality if they have HIV status, okay? It's not one of those exceptions to confidentiality, so you'll need to read about that. But if you do have a client that has HIV, you need to be clear with them up front about what the state law says, the limits to confidentiality, and you need to speak with them openly about your concerns regarding the danger of certain behaviors and risk to third parties. Okay? If the client continues to resist using safe sex practices or refuses to inform partners, then you have to think about what course of action to follow. Okay? So we'll talk about all of these things more in class, but again, the recommendations here is that you need to follow the statutory guidelines and safeguard the client's privacy as much as possible. But remember, you have a responsibility to the victims as well. So this has been our overview lecture. Be sure that you read your chapter. We've discussed confidentiality and related terms, balancing disclosures, legal precedents, mitigating risks, assessing suicidal behavior, vulnerable populations, and disclosures of HIV status. This concludes our overview lecture. Happy learning!